Welcome to the deep dive.
Oh,
Okay, I want you to just picture this for a moment. You're in an elegant dining room, white tablecloths, hush tones, that sort of thing.
mm-hmm.
It's July 2017. There's a professional gathering, a post-conference dinner for people in the legal world in New South Wales. Barristers, clerks, and barristers themselves are invited guests.
Right. A typical end-of-day industry function, relaxed but still professional.
Exactly. People are unwinding. But then in just a couple of shocking moments, all caught silently on CCTV, by the way, a respected barrister's career is about to take this incredibly dramatic, very public nosedive.
And this isn't your standard true crime story, is it? There are no detectives investigating a street crime here.
No.
This is a crime, if you want to call it that, against professional ethics. It plays out not in the criminal courts, but in the often quite unforgiving world of legal professional discipline.
Yeah, the consequences weren't about jail time. They were fought out in disciplinary tribunals and then all the way up to the state's highest appeal court. It's a real saga.
It really is. And it digs deep into some fundamental questions like, what does it actually mean to be a fit and proper person to practice law? What's the standard of character required?
So today, we're doing a deep dive into exactly that case.
Yeah.
Council of the New South Wales Bar Association, VEA. It all started with that one single, incredibly ill-judged incident at that dinner.
Mm-hmm.
We've got the key sources here, the detailed judgments from the NSW Civil and Administrative Tribunal at the NCT where it started, and then the really crucial judgment from the NSW Court of Appeal, which reviewed everything, plus a helpful summary article to sort of piece it all together.
It needs piecing together, believe me. We're talking multiple stages of legal action, different findings at different points, some really deep dives into legal precedent on professional standards. It's complex.
It definitely is. So our mission here is to guide you, our listener, through this whole thing. We want to unpack exactly what happened that night, then walk through the step-by-step legal process that followed.
Yeah, understanding the difference between professional misconduct, the really serious kind and unsatisfactory professional conduct.
Exactly. And crucially, what are the implications? Because this isn't just a story about one barrister, EFA. It's a pretty stark, maybe uncomfortable cautionary tale for anyone thinking about law or already in the profession. It really drives home the standards expected, even when you think you're off the clock.
It's fascinating, isn't it, how one act, apparently quite brief, committed while heavily intoxicated, could trigger such a long, complicated, and frankly, devastating journey, both legally and personally, for everyone involved, really.
Definitely. So let's set the scene properly. Part one, the setting and the players. You said it's this post-conference dinner, barristers, clerks, barristers as guests, July 2017, an upscale dining room in NSW. Meant to be pleasant, professional, social.
Right, that work-adjacent setting is key, because the connection to the profession, even socially, becomes a major point later on. Okay, let's introduce the dramatis personae, the key individuals based on the court documents.
First up, obviously, is EFA. He's the respondent barrister. The sources describe him as a seasoned Sydney barrister, so experienced, respected career up until this point.
And a crucial detail the tribunal noted. On the night in question, he was, quote, significantly intoxicated. Very important context, though, as we'll find out. Absolutely not an excuse in the eyes of the law.
No. Then there's H. She's an assistant clerk, attending the dinner. She was sitting at a table with her own clerk, W, and some other barristers. She didn't know Eva before this night. The whole incident revolves around Eve approaching her table, and she was the direct subject of conduct.
And her immediate reaction, her distress, and her complaint right afterwards that became absolutely vital evidence throughout the whole process.
Next we have A. He's another barrister, a male barrister, and described as a friend of EFA's. He was actually sitting right next to H at the table. EFA's interaction started with A, with this kind of ritualized greeting or horseplay, just before he turned to H.
We also need to talk about W. He was H's boss, the clerk of floor Y where she worked. H found him outside the venue immediately after the incident happened. His evidence was critical because he describes seeing H visibly shaken with trembling hands as she told him what occurred. Powerful, immediate corroboration.
Right. And there were others present too. F, another barrister from floor Y, gave a statement. G was another barrister at the same table. The tribunal mentioned someone called C, who actually walked over to the table with EFA. And P was mentioned as being outside with W when H came out.
So you've got this whole group, colleagues, acquaintances, in this professional but relaxed setting, and then bang. In less than 2 minutes, everything changes.
And that change, that incident, is what kicked off this entire legal saga. Which brings us to part 2. The incident unfolds. As you said, it lasted less than 2 minutes, and it was all captured on CCTV from 2 angles. Silently, though. No audio.
Yeah, that lack of audio was a real challenge for determining exactly what was said. But the visual evidence, combined with witness testimony and reactions, allowed the courts to piece it together quite definitively in the end.
So according to the facts found by both the tribunal and later upheld by the Court of Appeal, EFA walks over to the table where H and his friend A are sitting.
He first interacts with A. The tribunal called it a ritualized greeting.
Which the sources elaborate on, right? It, in part, parodied oral sex, involved a rude gesture. EFA apparently grasped A's head, simulating the act.
Yeah, and the tribunal noted this itself was inappropriate sexual conduct for a professional setting. But interestingly, they specifically found no evidence that H, sitting right there, was actually offended by that particular interaction between EFA and A. A fine distinction, but one they made.
Okay, but then EFA turns to H. He stands behind her chair. He puts his left hand on the back of her head. This is all visible in the CCTV.
Right, and the exact nature of what he did next with his hand was initially contested. H initially thought he moved her head towards his crotch. EFA denied it. But the Court of Appeal, after viewing the footage repeatedly, made a clear factual finding.
What was that finding?
They found he lightly pushed H's head forward towards the table. So away from him, towards the table surface. They explicitly rejected the idea, based on the video angles, that his hand was near his crotch, or that he guided her head that way.
Okay, so he puts his hand on her head, pushes it lightly forward towards the table. And while doing that, both the tribunal and the Court of Appeal found as fact that he said the words.
Suck my dick to H.
Wow. Okay. EFA denied saying those specific words.
He did, but the tribunal was convinced. They based it on the consistency of H's account. Her immediate reaction seen on the CCTV, that look of shock, and the fact she told W those exact words moments later when she was clearly distressed.
And the Court of Appeal backed this up.
Absolutely. They said the objective evidence, the video showing him speaking right at her, her visible shock, her immediate consistent complaint using those words provided, and this is their phrase, simply no explanation other than that he had said those words. It shows how courts weigh evidence, even without direct proof like audio.
And the context here is important too, EFA's intoxication.
Yes, the tribunal noted his significant level of intoxication contributed to his poorly judged actions. But, and this is crucial, both courts later emphasized, being drunk explains maybe why he did it, but it absolutely does not excuse it or lessen the misconduct.
A very brief interaction, less than 2 minutes, with massive fallout.
Exactly. And H's reaction was key evidence. The CCTV showed her shock. She left the table almost immediately to find W.
And W described her as visibly shaken, trembling hands. She told him she felt angry, upset, embarrassed, and humiliated.
The tribunal found her reaction was a reasonable and proportional response to what Eva did and said. Her immediate distress strongly supported her version of events, especially regarding the words spoken.
So the incident itself is July 21st, 2017. The formal process, turning this from a distressing personal event into a major disciplinary case, starts pretty quickly after that, which takes us to part 3, the immediate aftermath and the complaint process.
Right. Just 4 days later, July 25th, the executive director of the NSW Bar Association, Mr. Greg Tolhurst, gets wind of it from a director at Floor Y, where H worked. Statements start getting collected from HWAF.
Things moved relatively fast then. By August 2nd, Mr. Tolhurst writes to EFA saying his conduct is under consideration.
And the next day, August 3rd, 2 significant things happen. Mr. Tolhurst writes to the NSW police providing the statements. This was apparently to comply with a legal duty to report suspected serious offenses, though it seems, based on the sources, the police didn't take any action.
Okay. And the second thing on August 3rd.
EFA sends a written apology to H, but his position on what happened, it kind of evolved, didn't it?
Yeah, the sources detail that. Initially, he said he couldn't recall the specifics with H because he was drunk. Just remembered the horsing around with A. He accepted the A interaction was inappropriate. He denied saying, "suck my dick," but admitted he must have said something offensive.
Then later, after seeing the CCTV, he conceded the conduct with A, in H's presence, was coarse, inappropriate, sexualized. But even in his formal affidavit for the tribunal much later, he still denied uttering those specific words while accepting he'd offended her.
So The Bar Council considers all this, and on September 7, 2017, they make a formal complaint against EFA to the Legal Services Commissioner alleging sexually inappropriate conduct involving physical contact.
But these things can take time to refine. Over a year later, August 23, 2018, the Bar Council actually withdraws that initial complaint and lodges a new, more specific one.
More specific how?
This time, it alleged EFA made sexually inappropriate advances, including gestures, physical contact, and words spoken, to an assistant clerk H and to another in her presence. Notice the shift from just conduct to advances. That wording change signals the Bar Council was framing it as more serious, potentially hitting the threshold for professional misconduct.
Okay, so that sets the stage, and then the formal legal action kicks off.
Exactly. December 3rd, 2019. So, over 2 years after the dinner, the Council of the NSW Bar Association files the formal application for disciplinary findings and orders in the NSW Civil and Administrative Tribunal, NZIAT. That's the official start of the litigation.
And we should mention the legal teams involved at this stage, right? For the Bar Council and NCIAT.
Yes, the Bar Council was represented by Mr. Webster, SC, as senior counsel, and Mr. Madigan as junior counsel, instructed by Hickson's solicitors.
And EFA's initial team.
He had Mr. Bolton, SC, leading, with Mr. Horvath as junior counsel, instructed by Murray and Agnew solicitors. We'll see a change in lead counsel for EFA later, but Mr. Horvath and Murray and Agnew stayed involved.
Right. So this brings us to part 4, the tribunal proceedings. Stage 1, establishing the facts and characterizing the conduct. Explain how NCA works in these cases.
It's typically a two-stage process. Stage 1 is all about figuring out what happened, the facts, and then deciding if that conduct constitutes either professional misconduct or the less serious, unsatisfactory professional conduct.
And only if they find some form of misconduct in Stage 1 do they move to Stage 2.
Exactly. Stage 2 is then about deciding the penalty, the consequences.
So the Bar Council's application sought those findings, professional misconduct, or at least unsatisfactory professional conduct, based on those allegations of sexually inappropriate conduct and, more pointedly, sexually inappropriate advances.
The core job for the tribunal in Stage 1 was to sift through the evidence and make those crucial determinations. What happened and how bad was it under the legal definitions?
The Stage 1 hearing itself was in December 2020. That's over 3 years after the actual incident.
Yeah, these things can take a long time. The evidence included all those witness statements and affidavits, but critically, that CCTV footage.
And EFA and A claimed memory loss due to being drunk.
Pretty much. Which meant H was really the only direct witness to the specific words spoken to her. The tribunal acknowledged her communication style wasn't always perfectly clear or precise, but they accepted she was genuinely affected and trying her best to recall accurately.
And the CCTV was key, where memories differed.
Absolutely. The tribunal relied heavily on what they could actually see on the footage, especially regarding the physical actions.
So what were the tribunal's specific findings of fact in their Stage 1 decision, which came out in March 2021?
Okay, factually. They confirmed EFA lightly pushed H's head forward towards the table, away from him. They rejected, based on the video, any suggestion his hand was near his crotch or guiding her head that way.
And the words.
Crucially, they found as fact that EFA did say, "Suck my dick" to H while pushing her head. Despite his denial, they found the combination of the CCTV showing him speak, H's immediate shocked look, and her immediate report to W using those words was conclusive. They said there was no explanation for H's immediate distress, other than that it was an accurate reflection of what the barrister had said to her.
Okay, facts established. Then the hard part, characterizing that conduct legally.
Right. They found his actions towards H were clearly sexually inappropriate conduct, inappropriate sexual conduct, and unwelcome conduct of a sexual nature. They said a reasonable person would expect offense, and H was offended and humiliated, and her reaction was reasonable.
Seems straightforward so far.
But here's the hugely controversial part. The tribunal found that despite all that, it was not a sexually inappropriate advance.
Wait, sexually inappropriate, unwelcome, offensive.
Yeah.
But not an advance. How did they square that circle?
It seems they focused heavily on Ife's likely intent and the immediate context. They interpreted it as Ife being very drunk, making a clumsy, ill-judged attempt to sort of include H in the crude, jokey greeting ritual or horseplay he'd just done with his friend A. Rather than seeing it as a deliberate sexual move on H, they characterized it more as drunken, offensive behavior directed at her, but not intended as an advance in the sense of seeking sexual interaction or asserting dominance in that specific way. They called it very poorly judged.
That feels like a very fine distinction. calling conduct sexually inappropriate and unwelcome, but then saying it wasn't an advance because it was maybe just drunken horseplay extended to her. That sounds counterintuitive to how many people would see it.
It absolutely was, and that distinction fueled a lot of the subsequent criticism and the appeal. Based on that characterization, offensive, yes, sexually inappropriate, yes, but not an advance, and crucially, seeing it as an isolated, drunken, ill-judged act, the tribunal made its biggest finding.
Which was?
That the conduct did not amount to professional misconduct, neither under the old common law understanding, nor the main statutory test in Section 297 of the Uniform Law.
Okay, why not professional misconduct? What was the reasoning?
For the common law part, they felt his attendance at the dinner lacked a real and substantial connection with professional practice in the specific way required for that type of misconduct finding. The Court of Appeal would later disagree on how to interpret that connection, by the way.
And the statutory test, Section 297.
That's the key one. Does the conduct justify a finding that the lawyer is not a fit and proper person to practice law? The tribunal concluded that Ife's conduct, viewed as this isolated incident considered out of character based on references and done while drunk, did not justify finding him fundamentally unfit to be a lawyer.
So bad behavior, yes. Offensive, yes. Unwelcome, yes. But not bad enough to say he shouldn't be a lawyer anymore.
That was the tribunal's view in Stage 1. Instead, they found it did meet the lower threshold of unsatisfactory professional conduct under Section 296. Specifically, they said it breached the barrister's conduct rules about behavior that's discreditable to a barrister or likely to bring the profession into disrepute.
Which, I mean, saying suck my dick to a junior colleague at a work function seems pretty clearly discreditable and likely to bring the profession into disrepute.
You'd think so. And at the end of Stage 1, the tribunal also made an interim non-publication order using the pseudonym EFA and anonymizing HA and others, citing the sensitivity and concerns about EFA's mental health.
Now, when this Stage 1 decision dropped in March 2021, finding only unsatisfactory conduct, framing it as horseplay, not an advance, the reaction was huge, wasn't it?
Oh, yeah. Shockwaves, particularly in the legal profession, but also publicly. There's intense debate. Many people felt strongly that this behavior was professional misconduct, plain and simple, and that the tribunal's characterization felt like minimizing serious sexual harassment.
The horseplay and not an advance language really struck a nerve. Critics argued it seemed out of step with community expectations, especially around workplace harassment and power dynamics.
Exactly. Legal ethicists like Simon Rice publicly questioned how this could be deemed merely unsatisfactory, comparing it almost to minor procedural breaches. There was a feeling, fair or not, that the system might be protecting its own.
And media reporting, sometimes inaccurate, probably fanned the flames too.
It certainly added to the noise. It really highlighted this tension between strict legal definitions of misconduct and broader societal views on acceptable professional behavior.
So a very controversial Stage 1 decision. But it stood, which meant the process moved to Stage 2, the penalty.
Part 5, Stage 2, determining the penalty. The hearing for this was on May 12, 2021. The finding was unsatisfactory professional conduct. Now, what should the consequences be?
What did the Bar Council push for?
Even though they lost on the professional misconduct argument, they still wanted significant penalties. They asked for a fine. The maximum the tribunal could impose was $100,000, and they also wanted an order forcing EFA to undergo mandatory counseling.
And what evidence did EFA present in this stage?
He provided an affidavit detailing the steps he'd taken since 2017, dealing with alcohol, attending a health retreat, lifestyle changes. He also spoke about the severe personal impact, the end of his marriage, difficulties with seeing his children, the financial strain on his practice.
There was medical evidence, too.
Yes, very important. Reports from a clinical psychologist, Dr. Bowers, and a psychiatrist, Dr. Nielsen. They diagnosed him with major depressive disorder with anxious distress linked to the stress of the whole situation. And crucially, they reported he had had suicidal thoughts, though they assessed the immediate risk as low, partly because of his concern for his family.
Character references were submitted as well.
Yes, painting the incident as highly out of character for him.
So how did the tribunal weigh all this in their Stage 2 decision, which came out in June 2021?
They accepted the evidence of his rehabilitation efforts. They found there was no appreciable risk of him doing something similar again.
And they stuck to their view of the incident itself.
They did. They reiterated their Stage 1 characterization, not a sexual advance, not intended to intimidate or humiliate, but an ill-judged attempt to include H in a jokey greeting ritual while drunk. They felt confident he wouldn't repeat it.
So, based on that, no mandatory counseling.
Correct. They decided it wasn't necessary, given his insight, the isolated nature, and low risk of reoffending.
And the fine, the $100 K maximum the Bar Council wanted.
They rejected imposing any fine. Their reasoning was that a fine wouldn't really add much to general deterrence in this specific case, and they wanted to focus on the protective purpose of discipline, protecting the public, rather than pure punishment. They felt other consequences he'd faced were enough deterrent.
So what were the final orders from the tribunal?
Relatively light, you could argue. First, a formal reprimand. That's an official black mark on his record for the unsatisfactory professional conduct. Second, an order that EFA must pay the Bar Council's costs for the tribunal proceedings, which would likely have been substantial.
And the non-publication order.
They made that final and extended it for a very long time, 20 years, subject to limited exceptions for regulators, insurers, etc. Their reasoning was squarely based on that sensitive mental health evidence and the perceived risk to EFA if his name became public knowledge in connection with this, potentially jeopardizing his rehabilitation.
A 20-year suppression order is unusual, isn't it?
Highly unusual. It reflected the specific, serious concerns about his mental state presented in the evidence. But this outcome, just unsatisfactory conduct, just a reprimand and costs, plus the long suppression definitely kept the controversy simmering. Many felt it just didn't match the gravity of the act.
Which inevitably led to the next step.
Exactly. Part 6. The appeal to the NSW Court of Appeal. The Bar Council wasn't satisfied. They appealed both the Stage 1 finding, that it wasn't professional misconduct, and the Stage 2 penalty, just a reprimand, no fine, no counseling.
And this appeal was a full review, right? A rehearing.
Yes, meaning the Court of Appeal could look at everything afresh, the facts, the law, and substitute their own judgment if they disagreed with the tribunal. It wasn't just checking for legal errors.
Who were the legal teams for the appeal?
The Bar Council stuck with their team. Mr. Webster SC and Mr. Madigan, instructed by Hicksons. EFA kept Mr. Horvath as junior counsel and Moray and Agnew as solicitors, but brought in new lead counsel, Mrs. Kate Richardson SC.
And there was another party involved in the appeal, too.
Yes, the Legal Services Commissioner joined. This was because of a tricky legal issue about the public register of disciplinary actions. The law requires the commissioner to record these things, but how did that square with the tribunal's 20-year non-publication order?
So the commissioner argued for transparency. The name must be on the public register.
Pretty much. They argued the statute required it. EFA and the Bar Council at this point argued the non-publication order should prevent public access to his name via that register. A real clash between transparency and the court's protective order.
Okay, so the Court of Appeal hears all this. Their judgment comes down in December 2021. What did they decide? Let's start with the facts.
They reviewed the CCTV footage themselves multiple times.
Oh.
On the facts, they largely agreed with the tribunal. They confirmed EFA lightly pushed H's head towards the table, away from him, not towards his crotch.
And the words, "Suck my dick."
They firmly agreed with the tribunal's finding that EF did say those words. They found the objective evidence, the video showing him speaking, H's shock, her immediate report using those words was compelling and met the required standard of proof.
Okay, facts confirmed. Then the big legal question, professional misconduct or not, how did the court approach this?
They did a deep dive into the history of disciplinary law in NSW, and they made a really important clarification. In NSW, there's no separate common law category of professional misconduct. The only test is the statutory one in Section 297 of the Uniform Law. Whether the conduct would, if established, justify a finding that the lawyer is not a fit and proper person to engage in legal practice. That fit and proper person test is everything. It's about character, suitability, the whole package, not just the act itself.
Right. So did the court think the tribunal applied that test correctly?
They found the tribunal's reasoning was slightly off. The tribunal asked if the conduct established unfitness, but the correct question is whether it justifies a finding of unfitness, meaning, is it serious enough that a court could find you unfit, even if other factors lead to a different final outcome?
Okay, a subtle but important difference in the legal test. But what about the tribunal's conclusion? Did the Court of Appeal agree EFA's conduct didn't justify finding him unfit?
Yes, ultimately they did. Despite finding fault with the tribunal's reasoning process, they agreed with the final outcome on this point.
Why? That seems a bit contradictory.
It does, but again, it comes back to that holistic, fit and proper person assessment. The Court of Appeal looked at the whole picture, much like the tribunal did. They highlighted it being an isolated incident. It was presented credibly as out of character. There was strong evidence of genuine remorse and significant rehabilitation efforts, and crucially, they agreed there seemed to be no ongoing risk to the public.
They also said misconduct outside practice needs a stronger link to fitness, right?
Yes. Unless it's something like a serious crime, conduct outside practice needs a much more direct bearing on fitness to justify striking someone off. Ife's conduct, while they called it reprehensible, didn't, in their final assessment, considering everything, reach that ultimate level impacting his fundamental fitness to practice.
So the bottom line on the misconduct appeal.
The Court of Appeal dismissed the Bar Council's appeal on this point. The finding remained unsatisfactory professional conduct, not professional misconduct.
Okay. Then the court reviewed the penalty. What was their tone here?
Much stronger. They strongly condemned EFA's conduct. They used words like demeaning, humiliating, and inexcusable. They said it warranted severe condemnation.
Did they think a fine should have been imposed?
They stated clearly that in most cases, conduct like this would ordinarily attract a fine for deterrence. And they were absolutely emphatic. Intoxication provides NO mitigation, zero excuse. They sounded genuinely troubled by how serious it was, saying it was close to warranting harsher action.
Yeah, despite all that strong language, they didn't impose a fine either.
Correct. They declined to impose a fine. Why? Primarily because of the massive extra legal punishment EFA had already faced through his professional indemnity insurance.
The insurance premium.
Exactly. The evidence showed his premium had jumped from about $4,600 a year to over $66,000, plus a $50,000 deductible. The court said this financial hit dwarfed the maximum fine the tribunal could have imposed per $100. They felt this already served a significant deterrent purpose, making an additional fine unnecessary in his specific circumstances.
Okay, that makes sense in a way. What about the counseling order?
They also declined that, agreeing with the tribunal it wasn't necessary given his insight, the isolated nature, and low risk of repeating the behavior.
Finally, the non-publication order, the 20-year suppression. What did the Court of Appeal do with that?
They upheld it, but their reason was careful. They focused heavily on the psychiatric evidence about Ife's major depressive disorder and the assessed suicide risks if identified publicly. They applied the legal test for non-publication orders. Was it necessary to protect safety?
And they found it was.
Yes. Balancing the risk to EFA's safety against open justice, they concluded a limited order just suppressing information tending to reveal his identity was necessary. They stressed this was minimal impact on open justice, as the case facts and outcome were still public, just not linked to his name for 20 years. They also mentioned the prior inaccurate media reporting as supporting the need for protection.
So the 20-year suppression of identity stood, with limited exceptions for professional needs.
Correct. But then there was that crucial issue raised by the Legal Services Commissioner about the public register.
Right. Did the court's suppression order trump the legal requirement to put his name on the register?
No. This was a key finding for accountability. The court interpreted the laws and concluded that despite their 20-year non-publication order protecting his identity more broadly, the Legal Services Commissioner must still record EFA's name, his details, and the disciplinary action, the reprimand for unsatisfactory conduct, on the official register of disciplinary action, as required by Section 152 of the relevant act.
And can the commissioner publicize that information from the register?
The court found the commissioner has the power to publicize those details under the law, Sections 152 and 157(3). The court's non-publication order did not override that statutory obligation or power. They did add a comment that the commissioner would likely act sensitively in exercising that power, suggesting maybe careful consideration about how it's publicized, but the fundamental requirement to record it and the power to make it public via the register remained intact.
Okay, so let's recap the final Court of Appeal orders.
Appeal dismissed. Tribunal finding of unsatisfactory professional conduct stands. Penalty of reprimand and EFAing tribunal costs stands. Bar Counsel has to pay EFA's costs for the appeal. And the limited 20-year non-publication order on identity stands, but his name must go on the statutory register.
Wow, quite the journey. Over 4 years from that dinner incident to the final Court of Appeal ruling.
It really underscores how complex and drawn out these disciplinary processes can be, especially with appeals and sensitive issues involved.
Which leads us perfectly into Part 7, the implications and the cautionary tale. We've traced this case from start to finish. So what are the big takeaways? Why should you, listening now, especially if you're in or heading towards a legal career, pay attention to Ife?
There are some absolutely vital lessons here. Some might seem obvious, others are maybe more nuanced, but all are critical for lawyers to understand.
Okay, Lesson 1 seems pretty clear. Standards apply beyond the courtroom. This happened at a professional social function. Eve's case screams that your conduct at work, drinks, conferences, dinners, anything connected to the profession is fair game for disciplinary action. That line between personal and professional can get very blurry very fast.
Absolutely. Second key takeaway is about defining professional misconduct. The Court of Appeal clarified it hinges entirely on that fit and proper person test. It's not just about whether the act was bad or even illegal. It's whether it fundamentally shows you lack the character and integrity required to be a lawyer.
And EFA's case shows how that test works. It wasn't professional misconduct because the court considered mitigating factors of being isolated, out of character, the remorse, rehabilitation, lack of ongoing risk. Those things were weighed against the bad conduct.
Right, but it was a close-run thing. It shows that while not every bad act equals being struck off, the conduct still has to be serious enough to justify that finding, even if other factors pull it back from the brink.
Third lesson, and the Court of Appeal was loud and clear on this. Sexual harassment and inappropriate behavior are taken seriously. Even though the tribunal initially downplayed it as horseplay and not an advance, the court's condemnation, demeaning, humiliating, inexcusable, sends a huge warning signal. Any sexually inappropriate conduct towards anyone in the professional sphere is a major ethical breach.
Couldn't agree more. And lesson 4, hammered home by both courts. Intoxication is no excuse. Being drunk might explain why you acted foolishly or offensively, but it absolutely does not mitigate the misconduct itself. You're responsible for your actions, period.
Lesson 5 is maybe less obvious, but just as important. Consequences go way beyond formal penalties. EFA got a reprimand and had to pay costs. But the court explicitly recognized a massive extra-legal punishment from that insurance premium hike.
Yeah, that financial hit was huge. Plus the documented personal toll, marriage breakdown, mental health issues. And the reputational damage, even with partial anonymity, is immense. The case is studied, discussed. These are real severe consequences.
And that anonymity itself, lesson 6, anonymity is not guaranteed and not absolute. EFA got 20-year suppression due to very specific, serious mental health risks. That's rare. Most lawyers facing discipline are named.
And even with the order, his name had to go on the statutory register. So relying on secrecy isn't a viable strategy. The best protection is simply not engaging in the conduct in the first place.
Finally, lesson 7. Understanding the purpose of discipline. It's primarily protective of the public, of the profession's reputation, not just punitive. That focus influenced the penalty here, like not adding a fine on top of the insurance costs and balancing his health risks against open justice for the non-publication order.
It's about ensuring a trust in the profession.
Looking back, EFA's case really feels like it was on a knife edge, doesn't it?
It really does. The combination of factors, isolated incident, remorse, rehabilitation, no prior issues, plus the specific evidence on financial impact and mental health, probably just tipped the scales away from a finding of professional misconduct and being struck off.
But change any one of those factors if it was a pattern, if he seemed less remorseful, if the contact was different, if the extra costs weren't there, and the outcome could easily have been career-ending. It's a stark reminder of the high bar and the constant scrutiny lawyers are under.
That razor's edge between professional life and personal conduct, especially when connected to the profession.
So we've gone from that dining room floor through the tribunal stages up to the Court of Appeal's final word. This deep dive into Council of NSW Bar Association v. EFA shows just how tangled and serious professional discipline can get, all from one brief, terrible lapse in judgment.
It really lays bare those tensions, character, fitness, protecting the public versus the individual lawyer's situation, and potential for rehabilitation.
It does. And for you, our listener, thinking about all this, especially if you're in the legal field, here's that final thought to chew on. In today's world, hyper-transparent, digitally permanent, how does one single mistake, even outside work hours, echo through a professional life? How does it shape identity, public trust? What does EFA's story tell us about the need for constant vigilance at fit and proper standard expected of lawyers everywhere, all the time?
A sobering thought to end on.
Indeed. Thanks for joining us for this deep dive.